Question number 151. A magistrate convicts an accused of theft for 1 year imprisonment and 1000 rupees fine. Maximum punishment for which the accused can be sentenced to imprisonment in default of payment of fine shall be option A 1 year, option B 9 months, option C 3 months and option D 6 months. Correct answer here is option B, that is 9 months. Question number 152. If an accused at one trial is convicted of and punished with imprisonment in two offences under section 31 of CrPC, the imprisonment in the absence of any specific direction of the court will run option A consecutively, option B concurrently, option C consecutively as per direction of jail authorities, and option D none of these. Here correct answer is option A, that is consecutively. Question number 153. What is the difference between consecutive and concurrent sentences? Option A. When the sentence is suffered by the convict one after the other, it is said to be consecutive sentence, while if the sentence is suffered together, that is the lesser the sentence merging with the greater sentence, is known as concurrent sentence. Here correct answer is option A only. When the sentence is suffered by the convict one after the other, it is said to be consecutive sentence, while if the sentences are suffered together, that is the lesser sentence merging with the greater sentence, it is known as concurrent sentences. Question number 154. In the cases of conviction of a person of several offences at one trial, in no case shall such person be sentenced to imprisonment for a longer period than option A 14 years, option B 17 years, option C 20 years, option D 25 years. Here correct answer is option A, that is 14 years. Question number 155. Match list first with list second and select the correct answer by using the codes given below. Special Metropolitan Magistrate. Here correct answer will be imprisonment up to 3 years and fine. Chief Metropolitan Magistrate, imprisonment up to 7 years and fine. Judicial Magistrate second class, imprisonment up to 1 year and fine up to rupees 5000. Assistant Session Judge, correct answer is imprisonment up to 10 years and fine. So by going through these codes, correct answer here will be option A. Question number 156. Under CrPC, which one of the following courts can try a murder case? Option A, Magistrate of first class, Chief Judicial Magistrate, Session Judge, any of the above court. Here correct answer is option C, that is Sessions Judge can try a murder case. Question number 157. Which one of the following court can try a case punishable with life imprisonment? Option A, Magistrate of the first class, option B Sessions Judge, option C Chief Judicial Magistrate, and option D all of these. Here correct answer is option B, that is Sessions Judge. Question number 158. Under section 37 of CrPC, every person is bound to assist a magistrate or a police officer, option A, in the taking or preventing the escape of any other person whom such magistrate or police report is authorized to arrest, option B, in the prevention of suppression of a breach of peace, option C, in the prevention of any injury attempted to be committed to railways, and option D all of the above. Here correct answer is option D, that is all of the above. Question number 159. Which one of the following section of CrPC provides a public to give information of certain offences to the police officer? Option A section 38, option B section 40, option C section 39, and option D all of the above. Correct answer is option C, that is section 39. Question number 160. Arrest of a person is covered under chapter dash of the Code of Criminal Procedure 1973. Here correct answer is option B, that is chapter 5 of the Code of Criminal Procedure 1973. Question number 161. Under which section of CrPC a police officer can arrest a person without an order from a magistrate and without warrant? Police officer can arrest any person without an order from a magistrate and without warrant under section 41 of CrPC. Question number 162. The Supreme Court of India in the case of State of Haryana versus Dinesh Kumar 2008 held that arrest implies option A, apprehension of the custody by the police officer, option B, apprehension of the accused by the police officer or the submission of the accused to the custody by word or action, including when he is in the judicial custody, on surrender before the court and or submits to its direction, option C, handcuffing of the accused by the police officer, option D, handcuffing and putting the accused in police or judicial custody. Here correct answer is option B. Supreme Court of India in the case of State of Haryana versus Dinesh Kumar held that arrest implies apprehension of the accused by the police officer or the submission of the accused to the custody by word or action, including when he is in the judicial custody, on surrender before the court and or submits to its direction. Question number 163. Section 41 of CrPC deals with option A, arrest by magistrate, option B, when police may arrest without warrant, option C, arrest on refusal to give names and residence, and option D, arrest by private person. Here correct answer is option B, when police may arrest without warrant. Question number 164. Under section 41 of CrPC, the power of police to arrest a person covers all cases. Option B is limited to cases of mere suspicion. Option C is confined to cases of reasonable suspicion. Option D does not cover cases of army deserters. Here correct answer is option C, that is confined to the cases of reasonable suspicion. Question number 165. When police may arrest without warrant? Option A, who commits in the presence of a police officer of a cognizable offence who has been proclaimed as an offender by the state government, both A and B, none of the above. Here correct answer is option C, that is both A and B. Who commits in the presence of a police officer a cognizable case who has been proclaimed as an offender by the state government, both A and B. Question number 166. Under CrPC, police officer may arrest any person without an order from a magistrate and without a warrant. Here options are: who commits a cognizable offence in the presence of a police officer who has been proclaimed as an offender either under this code or by order of the state government. Option C, who obstructs a police officer while in the execution of his lawful duty. And option D, in above all circumstances. Here correct answer is option D, that is in above all circumstances. Question number 167. When can a police arrest a person without warrant? Option A, in case of cognizable offences only. Option B, in cases of proclaimed offenders only. Option C, deserter from armed forces only. And option D, all of these. Here correct answer is option D, that is all of these. Question number 168. A police officer may arrest somebody accused of an offence. Option A, to prevent such person from committing any further offence. Option B, for proper investigation of the case. Option C, to prevent tampering of evidence. And option D, for all of these. Correct answer is option D, that is for all of these. Question number 169. Consider the following statements. A police officer has the power to arrest any person without an order from a magistrate or warrant of arrest if he has a reason to suspect his complicity in a cognizable offence, punishable with imprisonment which may extend to 7 years, provided that he is satisfied for reasons in writing that such arrest is necessary. Option A, to prevent such persons from committing any further offence. Option B, for proper investigation of the offence. Option C, to prevent such person from tampering with or causing the evidence of the offence disappear. Option 4, to compel the absconding co-accused to surrender. Which one of the following above statement is correct? Here correct answer is option C, that is option 1, 2 and 3. Statement 4th is not correct, but 1st, 2nd and 3rd statements are correct. Therefore, option C will be the right answer. Question number 170. A police officer has a reasonable suspicion that K is involved in a murder case. He may, option A, inform the superintendent of police. Option B, inform the magistrate of that area. Option C, arrest K without warrant. Option D, obtain warrant from magistrate. Correct answer is option C, that is arrest K without warrant. Question number 171. Which of the following police officer may arrest such a person without any warrant who is under suspicion of deserting any of the armed forces of the Union? Option A, superintendent of police. Option B, inspector of police. Option C, officer in charge of police station. And option D, any police officer. Here correct answer is option D, that is any police officer. Question number 172. In order to arrest a person who is reasonably suspected of being a deserter from any of the armed forces of the Union, the police officer shall take prior sanction from dash. Option A, commanding officer of that person, state government, central government, none of the above. Here correct answer is option D, that is none of the above. Question number 173. The police officer shall record his reasons in writing while making an arrest in case of offences punishable with option A, imprisonment for a term which may be less than 7 years, imprisonment for a term which may extend to 7 years, option C, imprisonment for a term which may extend to more than 7 years or with death sentence, and option D, both A and B. Here correct answer is option D, that is both A and B. Imprisonment for a term which shall be less than 7 years, imprisonment for a term which may be extend to 7 years. Question number 174. If a person fails to comply with the terms of notice for appearance under section 41A subsection 1 of the Code of Criminal Procedure or is unwilling to identify himself, the police officer, option A, may subject to such orders may have been passed by a competent court in this behalf, arrest him for the offence mentioned in the notice. Option B, shall arrest him for the offences mentioned in the notice. Option C, may not arrest him for the offences mentioned in the notice. And option D, may without an order from a magistrate and without a warrant arrest him. In question number 174, correct answer is option A, that is may subject to such orders may have been passed by a competent court in this behalf, arrest him for the offence mentioned in the note. Question number 175. Procedure of arrest and duties of officer making arrest is provided in section dash of Criminal Procedure Code. Here correct answer is option A, that is section 41B of Criminal Procedure Code. Question number 176. Section 41B was inserted in the Criminal Procedure Code by the Amendment Act of which of the following year? Here correct answer is option D, none of these. Question number 177. Which one of the following is not a necessary requirement for a proper procedure of arrest under section 41B of CrPC? Option A, the police officer shall bear an accurate identification of his name. The police officer shall bear a visible and clear identification of his name. Option C, the police officer shall prepare a memorandum of arrest to be countersigned by the person arrested. And option D, the police officer shall inform the person arrested that he has a right of legal counsel during the interrogation. Correct answer here is option E, that is, the police officer shall inform the person arrested that he has the right of legal counsel during interrogation. Question number 178. Every police officer while making arrest shall, option A, bear an accurate, visible and clear identification of his name which will facilitate easy identification. Option B, prepare a memorandum of arrest. Option C, inform the person arrested unless the memorandum is attested by a member of his family that he has right to have a relative or a friend named by him to be informed of his arrest. And option D, all of the above. Here correct answer is obviously option D, that is all of the above. Question number 179. Every police officer while making an arrest shall prepare a memorandum of arrest which shall be attested by at least, option A, 1 witnesses, option B, 2 witnesses, option 3, 3 witnesses and option D, 4 witnesses. Here correct answer is option A, that is 1 witnesses. Question number 180. The memorandum of arrest to be prepared by every police officer while making an arrest shall be, option A, attested by at least 2 witnesses, one of which shall be a member of the family arrested. Option B, attested by at least 2 witnesses, one of which is a member of the family of the person arrested and other a gazetted officer living in the locally where the arrest is made. Option C, attested by at least 1 witnesses who is a member of the family of the person arrested or a respectable member of the locality where the arrest is made and shall be countersigned by the person arrested. And option D, as far as may be possible in the circumstances in which arrest is made, attested by at least 1 witness. Here in question number 180, correct answer is option C, that is attested at least 1 witness who is a member of the family of the person arrested or a respectable member of the locality where the arrest is made shall be countersigned by the person arrested. Question number 181. Memorandum of arrest of an arrested person is required to be signed and attested by 1 member of, option A, his family and 1 of his relatives, option B, the locality and 1 of his relatives, option C, other locality and 1 member of his family, and option D, his family member or member of the locality and countersigned by the arrested person. Here correct answer is option D, that is his family or a member of the locality and countersigned by the arrested person. Question number 182. Under section 41C of CrPC, state government shall establish control room. Option A, only at district level, only at state level, only at commissioner level. Option D, at state and district level. Here correct answer is option D, that is at state and district level. Question number 183. Under which provision of an arrested person has right to meet an advocate of his choice during interrogation? Here correct answer is option D, section 41D of CrPC. There is a provision of an arrested person has a right to meet an advocate of his choice during interrogation. Now let us proceed to question number 184. When any person is arrested and interrogated by the police, he shall be entitled to meet an advocate of his choice during interrogation, throughout interrogation, during interrogation, though not throughout interrogation. Option C is the correct answer, during interrogation, though not throughout the interrogation. Question number 185. A police officer has power to arrest a person accused of committing a non-cognizable offence. Option A, after taking permission from the superior officer. B, if he refuses to give his number and residence. C, in the presence of a magistrate. D, cannot be arrested in any situation. Here correct answer is option B, if he refuses to give his name and residence. Question number 186. Which section of Code of Criminal Procedure provides protection to members of armed forces from arrest? Option A, section 41. Option B, section 45. Option C, section 46, and option D, section 50. Here correct answer is option B, that is section 45. Question number 187. The member of armed forces cannot be arrested except after obtaining the consent of the, option A, Director General of Police, option B, central government, option C, Chief of the concerned armed force, D, magistrate. Here correct answer is option B, that is central government. Question number 188. Who is given protection from arrest under section 45 of CrPC? Option A, President of India. Option B, judicial officers. Option C, member of armed forces. Or option D, members of parliament. Correct answer is option C, that is member of armed forces. Question number 189. Assertion. The purpose of criminal law is to prevent crimes. Reason. In certain situations, even a private person can arrest another person. Option A, both A and R are true, but R is the correct explanation of A. Here, this is the correct answer. Both A and R are true and R is the correct explanation of A. Question number 190. The direction to ensure that police officers do not arrest accused unnecessarily and magistrates do not authorize detention casually were issued by the Supreme Court in the following case. Option A, Arnesh Kumar versus State of Bihar. Option B, Lalita Kumari versus State of UP. Option C, Sumita Kumari versus State of Bihar, and option D, Anju Chaudhary versus State of UP. Here correct answer is option A, that is Arnesh Kumar versus State of Bihar. Question number 191. Which section of the Code of Criminal Procedure authorizes the private person to arrest any person committing cognizable offence? Option A, Section 44, option B, Section 42, option C, Section 43, and option D, Section 45. Here correct answer is option C, that is Section 43. Question number 192. Any private person may arrest or cause to be arrested. Option A, any person who in his presence commits a non-bailable and cognizable offence. Option B, any proclaimed offender. Option C, both A and B, and option D, none of the above. Here correct answer is option C, that is both A and B. Any person who is in the presence of commits a non-bailable and cognizable offence, any proclaimed offender. Question number 193. A private person who is competent to arrest an accused as provided under section 43 of the CrPC can make a search of the arrested accused. This statement is true, false, partly correct, none of the above. Correct answer is option B, that is false. Question number 194. Which one of the following statement is not correct under the CrPC? Option A, where a private person or an authorized person has a right to arrest a person and hand him over to the custody of police, such private person can also make search of such arrested person. Inquiry and trial both are included in judicial proceedings. Complaint may be made by any person and it is not necessary that the injured or the affected only should complain. Option D, charges are framed only in warrant case. There is no need to frame charge in petty summon cases. In question number 194, option A is not correct. Other options are correct. Question number 195. Any private person may arrest any person who is reported to be criminal, in his presence commits a non-cognizable offence, in his presence commits a bailable offence, in his presence commits a cognizable and non-bailable offence. Here correct answer is option D. A private person can arrest any person who in his presence commits a cognizable and non-bailable offence. Question number 196. Which of the following is not a correct match? Option A, information cognizable cases, section 154 of Criminal Procedure Code, arrest by a magistrate, section 43 of the CrPC, arrest without warrant by police officer, section 41 of CrPC, contents of charge, section 211 of CrPC. Here in this question it has been asked which of the following is not correct. Arrest by magistrate is not a correct match, therefore B will be the right answer. Question number 197. Under which section of CrPC a magistrate can arrest a person? Here correct answer is option D, that is section 44 of CrPC. Question number 198. Section 44 of CrPC 1973 gives the power of arrest to option A, executive magistrates, option B, judicial magistrate, and option C, both A and B, and option D, none of the above. Here correct answer is option C, that is both A and B, executive magistrates and judicial magistrates. Question number 199. When any offence is committed in the presence of a magistrate within his local jurisdiction, he may, option A, only direct a police officer posted in a police station within his local jurisdiction to arrest the offender. Option B, order only a gazetted officer to arrest the offender. Option C, himself arrest or order any person to arrest the offender. And option D, none of these. Here correct answer is option C, himself arrest or order any person to arrest the offender. Question number 200. A magistrate in his presence under one murder took place during the morning walk. Whether he can arrest the culprit himself? Correct answer is option B, that is yes, he can arrest the culprit himself.